Okay, so with that, we'll get going. Keep in mind that this information I'm providing you today is general information. It's not specific legal advice for any of you. If you need specific legal advice for any individual company involved on this call or anywhere else, you'll need to contact me directly, and we'll do an engagement, and then I can provide you specific individual legal advice based on your circumstance. Also keep in mind that the situation is fluid, so the information here is as current as I can make it as of today, but we're getting guidance, and we're getting Q&As, and we're getting notices and so on from Department of Labor and IRS practically every day, and so the situation may change. Some of the things I say in here are said, I say what I think is the case, and some of them I say based on what the statute says and what my take on the statute is. And we might get some guidance subsequently that revises it. So if you're listening to this after today, keep that in mind. There are a couple of places within the webinar, within the PowerPoint, where I point you to two critical sites that everyone should bookmark. One is the IRS site dedicated effectively to COVID-19 and including a lot of information about the specific act we're talking about today, the Families First Coronavirus Response Act. And the other is a Department of Labor site that also has a lot of helpful information. They've got the notices that need to be given to employees, and they've got Q&As and a lot of other guidance there. So if you have questions, that's a great place to go, and that's also a great place for you to go and look for updated guidance as it comes out. There's a lot we have to get to, and I'm going to talk probably kind of fast to try and get through it all. It should take us right up about an hour to get through this, and then we'll have as much time as it takes to answer any questions, or to avoid your questions if I don't know the answer. And then, like I said, we can deal with individual questions, individuals as we go. So both the Emergency Paid Sick Leave Act and the Emergency Family Medical Leave Expansion Act, they work together, and they both take effect on April 1st, 2020, and they're going to sunset on December 31st, 2020. So it's just for the rest of this year. According to the IRS, you can voluntarily comply as of Friday, March, not Friday, March 2nd, that's Friday, March 20th, for purposes of the tax credit. We'll talk a little bit more as we go through about how the tax credits relate to the requirements that you provide the leave. So some of you might decide to voluntarily comply before April 1st, and some of you might decide not to voluntarily comply before April 1st, depending on your circumstance, and I'll give you some clues about how you might make that decision as we go through here. It also applies to private employers that have fewer than 500 employees. So if you're a private employer that has more than 500 employees, none of this applies to you, and you can hang up and go do whatever it is else you were going to do today. Every employee counts for the purposes of determining whether you have 500 employees, regardless of whether they're full-time, part-time, on leave, however you designate somebody. If they're on your payroll, they're an employee, and they count towards the 500 count. The Act also applies to governmental employers, regardless of the number of employees. I'm not focusing on that here. I'm focusing this webinar on private employers, and a lot of the provisions will they apply equally, but the focus here is on the impact on private employers. So the way to think about it is you've got two leaves. You've got emergency sick leave, and then followed by emergency family leave if it applies. And so because I don't like to make things too simple, emergency sick leave applies to every employee. It doesn't matter how long they've been employed. If they're your employee on the day they request leave, and you're an employer that has fewer than 500 employees, then the emergency sick leave provisions apply to them. But for the emergency family leave purposes, it only applies to employees who have been employed for 30 days. So there may be the odd person who doesn't get the emergency family leave, but does get the emergency sick leave. That's something to watch out for. An employer of an employee who is a healthcare provider or an emergency responder under the statute can elect to exclude them from the application of the Act. And I think the purpose there is effectively so that you can make them work and not give them time off because they're in such an essential business. The DOL, as far as I know, hasn't issued regulations regarding that, and it has authority to do so. So if you're one of those employers and you're thinking of excluding your employees, you'll need to dig deeper into that. I haven't done that at this moment. DOL can also, if it wants to, issue regulations to exempt small businesses with fewer than 50 employees from both of the requirements, but only if the statute says that if the imposition of the requirements, the leave requirements, would jeopardize the viability of the business as a going concern. The DOL has said that you can take a good faith position on that currently. You will have to notify the Department of Labor at some point of your justification, and they're expected to issue regulations in April governing how you do this. They don't want people sending anything to them at the moment saying, hey, I'm claiming this exemption. And furthermore, as we go through this, I think it'll become pretty clear that while there is an administrative burden to this, it's probably not something that you want to exempt yourself from, because in the end, it's basically a benefit to your employees at the cost of to the federal government in terms of the payments that are made to the employees. And the DOL can also issue regulations to ensure consistency between the two acts, the sick leave and the EFMLEA leave. Their Q&As have done so to some extent, and we're going to talk about coordinating the two types of leave here during this webinar. So let's move on now to the first leave, which is emergency paid sick leave. That's what starts at that's the beginning, chronologically, the first leave that somebody could be entitled to, and it can be taken for 6 different reasons. The premise behind being able to take paid sick time is that the employee is unable to work or telework due to a need for leave because of one of these reasons. So that's the first point I want to emphasize. If the reason the employee can't work is because they're not allowed into the office is closed, for example, and they don't have the ability to telework, so they can't work at all, even if they didn't have one of these qualifying reasons, well, then they're not qualified for the leave. They're only qualified for the leave to the extent that they can't work because of one of these qualifying reasons. And the first reason is if they're subject to a federal, state, or local quarantine or isolation order. One of the questions here that is not crystal clear yet, but I think has become a little clearer since the statute was passed, is what does it mean to be subject to an isolation order? We have some cities under a general shelter-in-place kind of an order. Is that an isolation order related to COVID-19? I don't think it is. It's my read of the statute, and also this is consistent with the way the notices and the Q&As that the Department of Labor has issued, the language they use. My take on it is it's an order directed at an individual. So you get quarantined because you've been diagnosed, and somebody in a federal or state quarantine order applies to you directly. It says, so-and-so, you need to quarantine, or you need to be in isolation. The distinction, I think, between a quarantine and an isolation is quarantine is if you've been diagnosed, and isolation is if you're a suspected case and you're isolated pending, because you possibly could contaminate other people if you have COVID-19 or the virus. The second reason is that the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, which I think is basically the same thing I was just talking about, except it's not pursuant to a federal, state, or local quarantine. It's pursuant to your healthcare provider saying, "Hey, you should quarantine yourself." And the third reason is the employee is actually experiencing symptoms of COVID-19 and is seeking a medical diagnosis. So this is the period before they've been diagnosed or gone and determine whether they have the virus or not. Those 3 are in one category, and then the 4, 5, and 6 are in another category, which we will talk about when it comes to how you have to compensate people for this kind of leave. So the first ones are very personal. The second ones are, there's a step removed where you're caring for somebody who is subject to one of these situations, and that's why that's the distinction anyway. So the fourth one is the employee is caring for an individual who is subject to one of those quarantine or isolation orders, or has been advised by a healthcare provider to self-quarantine. Basically, number 1 and 2 above. If you're caring for one of those people, then you get paid sick leave. Or if you're caring for a son or daughter, if the school or place of care of the son or daughter has been closed, or the childcare provider of your son or daughter is unavailable due to COVID-19 precautions. Interesting, note the language here, precautions. So it's not only due to a government order. So if we had a situation where the government said schools are allowed to reopen, but a particular school says we're not reopening because we're concerned about COVID-19, so that would be definitely within the statute. That's a precaution that makes the school closed, but it's not subject to a government order. And the language that they use, the parallel language that they use with respect to the extended leave beyond the first 2 weeks of paid sick leave, which is, in other words, the EFMLEA expansion leave, isn't the exact same language, and we'll get to that. It seems to be, in the statute, a little bit narrower when it comes to the extended leave beyond the first 2 week period. But we'll talk about that. I'm not sure if that actually has application or not. It's not quite clear yet. And then number 6 is other substantially similar conditions which can be specified in regulations. We don't have any such regulations, and I suppose that's probably just a catch-all in case, because they put the legislation like they are doing everything now, they put it together so fast, they probably figured, what if we miss some obvious thing? We want to allow some regulations to take care of that. So that's the reasons for the leave, for sick leave. Broad, really 6 different reasons. And then that goes for 2 weeks, which we'll talk about. And then the reason, then it narrows down beyond those 2 weeks to the emergency EFMLEA expansion leave. And that can only be taken because an employee is unable to work or telework due to a need for leave to care for a son or daughter under 18 years of age of the employee, if the school, place of care has been closed, or the child care provider is unavailable. And here's where the language varies in the statute. I don't know why. Due to an emergency with respect to COVID-19 declared by a federal, state, or local authority. So I think probably the way the Department of Labor is going to interpret this is just to say it's the exact same thing. If we have an emergency declared by the federal, state, even if it doesn't require you to close the school, but you stay closed because of concerns, or precautions, then they probably will say this leave still applies. But it's not 100% clear at this point whether that is the case or not. Hopefully we'll get that clarified. So let's talk about how much leave do you get? How much leave do you need to give your employees? Emergency pay, for the emergency paid sick time, that's the first leave that they get. Full-time employees are entitled to 80 hours of paid sick time, and part-time employees are entitled to a number of hours equal to the number of hours that they work on an average over a 2 week period. And that creates, so if you have full-time employees, and I think the read on this is if you define full-time for your purposes as, say, 36 hours a week or more, if that's how you define full-time, then they get 80 hours a week. And if it's part-time, then they get less. So that's kind of be more generous rather than say, oh, 36 hours, I call that full-time, but that's not really full-time because it's not 80 hours every 2 weeks. Don't do that. I think you need to be generous. The whole purpose of this thing is to give leave, and that would be a reasonable interpretation. When it comes down to your part-time employees, I think you apply a similar kind of a rationale to those people whose hours may have been reduced in the last couple of weeks before today. Let's say we have an employee going out on this leave today, and over the last 2 weeks, they've only been working half-time because of a business slowdown. I don't think you say, oh, they only worked half-time, therefore they're only entitled to half-time leave. It's probably the regular schedule that they worked. You should probably apply the regular schedule that they worked before this whole situation started impacting your business. Hopefully the DOL will issue some guidance, and when there are some parallel provisions about how you pay people for if their schedule is such that it's not possible to know how many hours they would have worked. If it's such a variable hour schedule, Then they have some rules about looking over a 6-month period or over the extent of their employment. Even though those don't directly apply to part-time employees, I think you should probably apply some reasonable thing like that, rather than try and whittle the leave down to way less due to a business slowdown. Again, the purpose of the Act is to provide paid leave. The feds are paying the costs for the most part, and you get a tax credit. So you don't really have much of an incentive to try and not give as much of this leave as you can, except you don't want to push it obviously too far and not get the tax credit that you're counting on. For emergency EFMLEA leave, so effectively what that means is that the sick leave is 2 weeks at somebody's regular rate. If they're full-time, 80 hours is going to be 2 weeks of pay. And if they're part-time, it's going to also take 2 weeks. But if they're, well, we'll get to what happens if somebody's a full-time employee regularly, but now is only able to work half-time. That will change how long it takes to use up all their sick leave, which we will talk about. It could take more than 2 weeks to use it up if they're not using it at the rate of 80 hours a week, every 2 weeks. So the emergency EFMLEA leave is for 12 weeks of total, and it's unpaid for the first 10 days, which effectively means that for those first 10 days, somebody who qualifies for this EFMLEA leave will also qualify for the paid sick time, because the only basis to qualify is if you're taking care of a child who's off school or out of childcare because of the situation. So it parallels that provision in the sick time law. So the reason it's unpaid for the first 10 is because those first 10 days would be paid under the Sick Time Act, and then this kicks in for those few people and extends it all the way up to the EFMLEA period of 12 weeks. Like under EFMLEA, the Act says that they can substitute accrued vacation leave, personal leave, or medical or other sick leave during those first 10 days. Makes no sense to me. That I don't think that actually applies as a practical matter, because of that fact that anyone who qualifies for this leave, while the EFMLEA leave would be unpaid, it would be paid under the Sick Time Act, which comes first before anything else. And so as a practical matter, you're never going to be substituting somebody out. And then for the last 10 weeks of this leave, it is paid, which means it's a total of 12 weeks for the people who qualify for the EFMLEA extension leave. Both earned paid sick time and the EFMLEA extension leave are based on, how much you have to pay them is based on two things. What is their regular rate of pay under the Fair Labor Standards Act? And you're going to use either 100% of that amount or 2/3 of that amount, depending on which kind of leave you're paying, and we'll get into that on subsequent slides. But it's that regular rate of pay, or 2/3 of it, multiplied by the number of hours that the employee would otherwise be normally scheduled to work. So it's the number of hours that they would be working, but for the fact that they need the leave that qualifies them for this pay. So the other thing is the number of hours that you pay them for is the number of hours that they would have otherwise be normally scheduled to work. So if you have a work reduction, let's say you have an employee who is in a position where they're full-time, but because they're not allowed to come into the office, you've shut your office, and they can, let's just say they can telework half-time. But because of the nature of what they do, they can't telework full-time. You would start from the proposition that they're only working half-time when it comes to figuring out how many hours do I actually have to compensate them for, not how many hours of leave do they get, how many hours do I have to compensate them for in a given week or day. And that would start from the 20 hours. And then you say, okay, how many of those 20 hours that you would be working can you not work because you have to take care of a child, or because you're sick from coronavirus, or in quarantine, or whatever the qualifying reason is. So the number of hours you actually have to pay, this is where they get into the variable hour schedule. When the statute talks about how many hours you have to pay somebody for. Now, let's say you've got somebody who is diagnosed with coronavirus and is at home, unable to do any work, because they can't telecommute and because they're sick. They have a variable hour schedule normally. How many hours do you pay them for? Because it's impossible to determine how many hours they would have worked in that actual week. And that's where you get into the situation of having to average the 6-month period if they've been employed for 6 months before, and that's the 6-month period before they took the leave, or the period of their employment. So it can get a little bit convoluted here, because that 6-month period would include a business slowdown in the meantime. And so that creates a little bit of difficulty in administering that and determining how much hours were in those people. So for sick, how much you have to pay, this is where we get into the distinction between the 100% of their base rate of pay or 2/3. So for the first 3 kinds of sick pay, which is the person is in quarantine, in isolation, or they're seeking a diagnosis for COVID-19, the rate that you have to pay them at is 100% of their regular pay under the Fair Labor Standards Act, subject to a maximum payment to them of $511 per day and $5,110 in the aggregate, which is 511 times 10. So if somebody is off work half-time, if they're able to work half-time and they're off work half-time because of the virus, and if they didn't have this qualifying reason, they would be able to work full-time, then you would be paying them for half a day. And so the maximum that you'd be paying them would be half of this. So it's per day, per full day, and if you're paying partial days, it would be adjusted for that. For sick time, caring for others, quarantined or home, these are the last 3 reasons of paid sick time, where you're caring for somebody else. The amount you get compensated per hour of missed work is 2/3 of the regular rate of pay, subject to a maximum of a lower maximum of $200 per day and $2,000 in the aggregate, which again is 200 times 10. And then when we get into the emergency family leave, it's the same at 2/3 with the same limits, $200 a day and $10,000 in the aggregate, which is 50 days, which is 10 weeks. So think of the person whose child is home, conceptually in your mind, the person whose child is off school, they're just in this 12-week at 2/3 of pay world. And that's going to be a lot of the people that qualify. Hopefully that'll be most of the people that qualify for this leave. What are the notice requirements for employers? Each employer is required to post and keep posted in the conspicuous places on their premises. This is the same place where you'd be posting all of your other notices, the Fair Labor Standards Act and FEMLA notices and all the other employer notices. The notice that has been issued by the Secretary of Labor. They've issued such a notice, and there's one for a federal, I think it's for government employers, and one for private employers. So make sure you use the right one. And if you get, this is the link that I told you about before, to the Department of Labor guidance site. It includes a link to the notice. It includes a lot of Q&As. It also includes an explanation that you can email it to your employees if you have an email address. So, makes sense that they would do that, since a lot of people are teleworking, and posting a notice in your workplace where nobody goes doesn't make any sense. The other thing you're going to need to do is to develop some policies for the leave and some forms for employees to request. I'm working on that right now. I'm aiming to have something out and available by Saturday night. I'll send out something, and there'll be a link where you can go check it out, and there will be a modest fee for that. But I'm putting this together so that you can tell your employees what they need to do in order to get the leave, and the documents and information that they're going to need to give you to support their leave request. The reason you want that is twofold. One, to make sure that you're giving them the ability to request the leave in a way that allows you to comply with the requirement to give it to them. And that's a Department of Labor issue. And perhaps the more significant reason is so that you can document the leave that you gave and that you paid people for, so that you can get the tax credits. IRS has said you're going to need these to document the reasons for the leave that you've granted, so that to support your tax credit request. The notice, more about the notice requirements. Statute says that after the first workday or part of the first workday that an employee receives emergency paid sick time, after that you can require them to follow reasonable notice procedures in order to continue receiving such paid sick time. So somebody basically gets day one to say, I'm not telling you, I'm just not showing up at work because I have one of these qualifying reasons. They tell you later, which makes sense. You don't want somebody waking up feeling like they have symptoms of the coronavirus and then worrying about having to tell the employer today. So, but they do, under the statute, you could request notice as soon as one workday later. I think you're going to want to think about giving a little bit more time for a couple of reasons. Number one, the more time you give, the more likely somebody's going to request it. And once they're off, you really want them to request it if they qualify, because that allows you to get a tax credit. Effectively, in the end, if you're otherwise paying the employee anyway, it purely benefits the employer. If you weren't going to pay the employee either way, well, then it still benefits you a little bit because you get to pay your employee, which is always a good thing if you can do it. And you're paying them with federal money. So you might want to give them a little bit more than one day to notify you. One of the considerations I think you need to think about is, does it kick you, if you give them too much time, does it kick you into the next pay period where you get the notice for a period where you've already paid them? Doesn't necessarily mean you won't go there. You might still be willing to go there, but it will increase your administrative complexity just a little bit, because then you will need to make some adjustment on the next payroll. Still totally doable. So somewhere between 1 and probably 7 days will make sense, but I think everyone needs to think about how much trailing time you have in your payroll period between the close of the pay period and the date you have to submit your payroll, and other considerations like what kind of a hassle you expect in terms of going back and adjusting prior pay amounts to account for leave that somebody, or reporting for that matter, for leave that somebody might claim after you've already paid them. And in any case where the necessity for emergency EFMLEA leave is foreseeable, which is when the school is closed and it should be foreseeable, the employee is required to apply the employer with such notice of the leave as is practicable. So these are kind of generic terms: practicable, reasonable. Who knows what that actually means in a particular case, but I think if you keep in mind the purpose of the statute, which is to provide money to people affected by being unable to work for these reasons, you will be in good shape. Hopefully we'll get some more guidance from the Department of Labor about these issues, about the notice, timing, and that kind of thing. Again, you need policies and procedures that's going to document the request so that you can get your tax credit and so that you can administer these programs. You're going to need to inform your employees of what they have to do to take the leave. In those policies, you're going to need to say things like, does it have to be in writing? Can it be by email? Can it be a telephone call to supervisor so-and-so, followed up by submitting the supporting documentation? You need to think about your workplace and think about what makes sense. I think in most cases, you're going to want something in writing, whether it's as a default, I would use a form and say, here's the form, fill out the form and send it back to me by email, by however, whatever works for you. If it's email, fax, carrier pigeon, whatever works for you. But the whole process needs to be focused on documenting the need and supporting the request for the leave. Some sequencing issues before April 1, and we're still a couple of days before April 1, or if you have an earlier voluntary compliance date, which we'll talk about in a minute, because you don't have to wait till April 1 to comply with these leave requirements. You should consider whether you want to, if you have, let's say you have some employees who are off work or on a reduced schedule, Look at your state mandated sick leave rules, and you might consider paying those employees, keeping them paid at full or more for more hours than they're actually working, using the state mandated sick leave requirements. For example, in Arizona, if your business was ordered closed, if you're say a surgery center or a gym or a restaurant, and you were ordered closed, I suppose actually restaurants haven't been ordered closed, but if you were ordered closed and there's no way you could be open, then under the because of this emergency health situation, then that qualifies for paying out sick leave under the Arizona law. And you may voluntarily also want to just allow people to take vacation pay before April 1. That'll diminish the obligations that the employer has under those leave programs. And then as of April 1, or if you pick an earlier voluntary date, if it's applicable, first you need to look, do they qualify for emergency paid sick time? And that comes first for all employees. It comes before anything else. If they qualify for that, they get that before vacation, they get that before state mandated sick leave, they get that before anything else that you might be thinking that you're going to pay them. That's their right to get that, and it comes first in line. If they're off work for the sick time, to care for a child whose school is closed. For those people, you're not allowed to substitute any other leave. Then if the sick leave is available under the EFMLEA, the extended EFMLEA, consider whether that's available after the sick leave runs out. After the first 2 weeks runs out. How much, let's give an example here. Let's assume we have a full-time employee who's paid at a rate of $30 an hour, and assume that they could work full-time at home, except that their child is off school due to a school closure, and so they can only work half-time, because the other half of the time they have to take care of their kids. And they're going to tell you how much they're going to need to tell you, because my kids are off, I can only work half-time. You're going to just have to take what they tell you and require them to tell you. Some people, they would, in this circumstance, wouldn't be able to work 20 hours a week. Some might be able to work 20 hours a week because they have a spouse who can take care of the kids the rest of the time, or because the kids are off with grandma or something, who knows. But assume that they can only work 20 hours and they would normally work 30 hours. So that you pay them their full wages, which would be $30 for the 20 hours per week that they actually do work. And then you would pay the other half, the other 20 hours at $20 per hour, which is 2/3 of their 30-hour regular rate of work. And in that circumstance, for 1 week, they would use 2.5 days of unpaid sick time. So this hypothetical employee could stay on this paid sick time for a total of 4 weeks before they start getting into the emergency family paid sick leave. So let's talk a little bit about some of the other aspects of the Emergency Family Act. It has regular family requires reinstatement after the end of the family leave to the same or a substantially similar position, and that same rule applies to the leave that somebody takes under the Emergency Family Act, except in the case of employers that employ fewer than 25 employees. You get a little bit of a special dispensation on holding open as the same or substantially similar position, if you have it, for these employees who take this kind of leave. For those people, for those employers with less than 25, you don't have to comply with the regular family restoration rights if you comply with certain conditions. And the conditions are that if the position held by the employee when they terminate their emergency family leave doesn't exist anymore due to economic conditions or other changes in your operations that affect the employment and that are caused by this COVID-19 emergency declared by the federal, state, or local authority. So if their job doesn't exist because of this whole situation, then you don't have to restore them if you make reasonable efforts to restore them to a position equivalent to the one that they held when the leave commenced with equivalent benefits. And if that's not possible because there is no equivalent position, then basically you have to run 1 year out and notify them and contact them if an equivalent position becomes available for 1 year after the act. So basically what this means is people who qualify for the emergency paid sick time, for the emergency EFMLEA pay leave, when you reopen your operations, if you've laid off or furloughed a bunch of people and then you gradually ramp up your operations again, you're going to effectively need to put these people in the front of some lines where there is an equivalent position for them. They're going to need to get the first stab at that equivalent position. And if there is no equivalent position, then you're going to need to keep reviewing whether an equivalent position opens after you reopen your operations, or basically for the year after they terminate their emergency EFMLEA leave, and notify them, hey, equivalent position opened. We don't know, there's all kinds of details about, how often will you need to review and notify them? Well, I think it's basically runs all the time. But what you will need to do as a practical matter is not clear. And frankly, I haven't thought that much about it because it's not today's problem. Other notes, and these are kind of some random notes about these acts, which didn't fit anywhere else. Wages that you're required to pay by reason of the acts are not considered wages for purposes of the employer's Medicare tax, but they are subject to the employee FICA taxes. So you don't withhold, you do withhold from the pay you pay to people, you withhold the employee's portion of the FICA taxes, but you do not, under the statute, you do not withhold, you do not have to contribute the 6.2% Medicare tax of the employer. And we'll talk a little bit more about that issue when we talk about the credits. Another point is you can, if you want to, pay more than the minimum amounts, the 2/3 of the regular rate, and you could charge then the excess that you pay them against other applicable pay time if it applies, like paid time off or state mandated leave. That would not be putting that leave in front of the federal leave, it would be putting it behind the federal leave. And so consider, for people in this position who you're paying 2/3, consider, do I want to pay them 100% and keep charging against other leave banks that I might be able to charge against? The statutes also include anti-retaliatory provisions, just like every other benefit and employment-related law. You can't retaliate against somebody for taking the leave. You can't retaliate them for complaining about not getting the leave, even if they're wrong, even if you didn't deny them something. If they complain, you can't retaliate against them for complaining or for going to a government agency and complaining. Keep that in mind when you reopen. If you have somebody take this leave, particularly if they're not happy about something else as well, and they're, all your regular red flag, radar screen type stuff should go up for when you're rehiring somebody and considering, specifically if you're considering not rehiring somebody or not bringing somebody back, or if you're bringing some people back and not others, consider the implications of the anti-retaliatory provisions for people who have taken this kind of leave. The other thing is, if somebody doesn't use up all of their paid sick time or emergency EFMLEA leave under the acts, you don't have to pay it out. You only have to pay it if they take it, and it doesn't roll over to next year, and that's obvious because statute only runs through the end of this year. The DOL is required to issue guidelines to assist employers in calculating the amount of sick time under the act. The Q&As, I think, address a little bit of that. I'm not sure they add anything yet particularly detailed. We might get some more guidance of that. They can also issue guidance to ensure consistency between the two acts. And I think that my guess is that guidance is going to say effectively what I told you earlier on, which is when somebody qualifies for this leave because their child is off school, their school is closed or the child care center is closed, that person's going to get 12 weeks of leave. And the coordination will be the first 2 weeks or the first 80 hours for a full-time employee, which means also the first 2 weeks of intermittent leave taken under it are under the emergency paid sick time, and then they go right into the 10 weeks of the emergency EFMLEA leave. Enforcement is up to Department of Labor, and they can enforce the payments requirements, the requirement to pay this sick time under the Fair Labor Standards Act, just like failure to pay minimum wages and overtime. Violations of the emergency EFMLEA payment requirements are enforced under EFMLEA, also by the Department of Labor. And the DOL has helpfully issued us some guidance saying that, and this is on the DOL website that I gave you the link to earlier, that they're going to observe a temporary 30-day non-enforcement period after April 1st, so long as you act reasonably and in good faith. And I think if you do what we're outlining here, that you'll be in good shape to defend that you acted reasonably and in good faith. And that means that, in addition, if you identify a violation, so let's say you do something and the guidance comes out and you realize, whoops, I've completely messed this up, well, then you need to remedy the violation and make the employee whole, put them back in the position they would have been in had you not made that mistake. And your violations were not willful, and they receive a written commitment from you to comply with the act in the future. Don't send anything like that yet. Wait till we get some guidance about that before you do that. And obviously, if you make a mistake, let's talk about it before you correct it, so you do it. So we do it in the way that is most defensible. What if an employee? Some questions here. What if an employee can work remotely from home? If they can work full-time from home, then they're considered to be able to work full-time. And then you go into that analysis I talked about before, which is how much time can they not work because of the qualifying reason, and that's the amount of leave they get. But if they're unable to work from home and they're unable to work in the office too, well, then they're unable to work for any reason having nothing to do with their qualifying reason for the leave, then they don't get paid anything under they're not required to be paid anything under the acts. Intermittent leave does appear to be permitted, as I've alluded to throughout the presentation. Can an employee work part-time for the employer during the FMLA time period and get a partial paycheck from work and then a partial payment through the approved leave? Absolutely. I think I've already answered that. Basically, if the reason they can't work full-time is due to a qualifying reason. What happens if an employer closes down an entire divisional location and furloughs its employees? It depends a little bit on the reason. Actually, it doesn't. It doesn't. If you have to close your location and no employee is working, regardless of whether they have a qualifying reason, then there is no obligation to pay them. Interestingly, though, and under existing FMLA regulations, they say if somebody's on FMLA leave and you have to close your business, like manufacturers close for 2 weeks over the Christmas period, or some period to retool the factory, and they send everybody home and furlough them for a couple of weeks. If the facility is closed so that they literally couldn't work if they wanted to, then they still are on FMLA leave, but the FMLA leave, but the time of the business closure doesn't count against the 12 weeks of FMLA leave. And I think the same rule would apply here. So you might theoretically have somebody who, you've closed your business already, let's say, and somebody has this qualifying FMLA leave reason, child off school. They are entitled to the emergency FMLA leave, the first 10 days of which are unpaid. And none of those days start counting until they actually would otherwise be back at work. So you don't have to pay them, but perhaps they would get the reinstatement rights. They probably would, logically, under the statute, even though they never really went on FMLA leave. Well, they did because they had the qualifying reason. So I'm getting dancing a little bit on the head of a pin there, but that circumstance could come up. What if you need to do a layoff or a reduction in force, say after the acts have been in place? What impact do they have on the layoff or the RIF? Really, they have an impact, but not a direct impact. It's the same as if your employers or any other form of leave, FMLA or ADA leave. You have to watch out for retaliation when you're implementing your layoff or reduction. So it's like they're one of those people that has a red flag that should be waving at you that says, watch out how you deal with this person when you do your layoff or reduction. If you have to close the whole facility, well, then it's pretty straightforward. Everyone's affected. If you're picking employees, there may be an issue where you have to watch out for the order of protection that these people on this leave get because of the anti-retaliation provisions. If you've already implemented a furlough before April 1, 2020, do you have to allow them access to the program? I already discussed that. You don't have to pay them until they would actually be at work, but would theoretically get the protections. They would actually get the protections of the EFMLEA Act. So let's talk about the tax credits. When do you take your tax credit? First of all, the credit itself for the payments you make under the Act are allowed against the employer's 6.2% Medicare tax. The IRS has said that as of Friday, or they said on March 20th, they said effective immediately, the credits are allowed. So that's the early effective date allowed under the statute. You could be getting a credit if you have the documentation, or if you get the documentation for pay that you've paid to people. I would say safely do it as of the beginning of this week, Monday, if you want to. The issue there is, if you pay them if you take the credit now, I believe, well, the credit parallels the amount of leave that you're required to give under the Act. So you don't get more credit if you decide to pay more, say more than 12 total weeks to somebody. You don't get more credit. The credit runs out for you. So if you've already been paying people this week and somebody qualifies for the sick leave and you get them and you decide to have a retroactive date, you could recoup some of the money you've paid them that you've otherwise already paid them and would have paid them because of the policies you've adopted, perhaps to keep people on pay. But they can tell you next week, hey, I wasn't able to work last week full-time. I would have been paid full-time anyway, but I was still qualified. You could recapture some of that money that you've paid through the tax credit. The issue is that it'll reduce it on the back end. You'll lose the credit on the back end because you only get a total of 12 weeks, but you will still be required, at least this is my current take on it. If you implement the early credit here, you will still be required by Department of Labor to provide the full amount of paid leave starting as of April 1. So you might end up losing the extra credit that you got here on the back end. So only do something like this if you think that you're never going to use it all up, all the 12 weeks. And if you've already been paying people full-time this week. If all of that is too confusing, just go with April 1st as the effective date. IRS says and your reimbursement is equal to 100% of the qualified sick leave and the qualified family leave wages paid during the quarter. Those are two defined terms which we will talk about in a minute. The IRS says that reimbursement will be quick and easy to obtain. This is what they said on Friday, and they said they were going to issue guidance this week. I haven't seen it yet, but they may have issued it, or they will issue it very soon. The way they described it, they said it will be an immediate dollar-for-dollar credit against the payment of taxes withheld for federal income, for the employee share of FICA, and the employer share of FICA taxes with respect to all other employees. So you're pulling on a lot of different sources for the tax credit. This, like I said above, at the top of the slide, the statute says it's against the employer's Medicare tax obligation, but the IRS is saying you can take the credit against all of the income tax withholding that you do, as well as against the withholding you do against employees' share of FICA taxes and the employer's share of FICA taxes with respect to the other employees. And if that's not enough and a refund is owed, then the IRS says they'll send the refund as quickly as possible. They said within 2 weeks. Any credit over the tax actually paid is an overpayment, and you can get an expert. The IRS says they're going to put in place an expedited advance system to streamline your claim, and they're going to release guidance on that this week, and you'll be able to get it within a couple of weeks. You can also claim it at the end of the quarter on a 941X tax return, or take it as an interest-free credit against your future obligations, so you could carry it over from one pay period to the next. Importantly, any refund that the employer receives, which would be the credit in excess of the tax actually paid, is taxable income to the employer. So what are qualified sick leave wages and what are qualified family leave wages? Those are the wages that are normally subject to FICA taxes, which are paid pursuant to the Act. So that's all those dollar amounts we were talking before, the hours times 100% times 2/3. The rate times those percentage multiplied by the hours, up to the maximums that we talked about before, the 200 and 511 per day, or the 10 times that or 50 times that under the 2 Acts. But it's also increased by amounts that are paid by the employer to provide and maintain a group health plan, as such amounts are properly allocable to the qualified sick leave wages for which credit is allowed. We're likely going to get some guidance from the IRS about how to allocate the healthcare, the health plan costs. So it's, the big point here is it's more than the dollar amounts you pay in actual wages. You get a little bit more of the credit based on the group health plan costs. In the absence of guidance from IRS, which we will get at some point, I'm sure, the statute says you can prorate the group health plan costs amongst your covered employees. So you take the total cost of providing group health plan to all of your employees, and you divide that by each covered employee, and that comes up with a dollar amount. So you don't have to say, oh, this employee who took the leave is on family coverage. That's a higher number than average, or conversely, this employee who took the leave is on self-only coverage, and that's lower than the average. You just take the average overall, and it washes out. So it might work to your advantage, or it might work less to your advantage. And then once you've done that, you allocate it pro rata on the basis of the period of coverage, like the month, which would be in practically every case. It's coverage is on a monthly basis, and the costs are on a monthly basis. And you do that relative to the time periods of leave to which such wages relate. And so what you're going to be doing then is looking at how many, what percentage of time did I pay the wages for this person for this month, and allocate a portion of the group health coverage that way to the hours that they worked, or compared to how many they would have worked had they not had the qualifying leave. So this is how I think it works roughly. Let's assume employer has $25,000 total healthcare premium costs for the month, for April. They've got 50 employees covered by the plan. That means they're paying $500 per employee. If employee A is paid for 10 days of sick time in April and works full time for 10 days, then it's easy because half the time is worked and half the time is not worked due to the leave. Then you would allocate $250 to them, and that's how much you get as an additional credit. What if they don't work at all, or if they're working on a reduced schedule due to business reduction? Say prior to business reduction, prior to their leave, we reduced them to a half-time schedule, and now they take the leave and they get all of the rest off. In that case, you probably take the 10 days of leave that you paid them and divide it by the number of work days that they would have worked had they not been on the sick time. So if your business is shut down and nobody's able to work, there's no sick time requirement at all, and obviously no credit. But if your business is on say half schedule, or the employee is on a half schedule and they take the leave and they're reduced to no work at all because of the leave, well then 100% of the cost per employee would be allocated to that employee, because 100% of the reason 100% of the time that they were covered, they were being paid for sick leave as opposed to working time. Self-employed business owners can get these credits, and they're calculated in a very similar way. That the credit it's a refundable credit, so it's the same concept. If it's excess over tax paid, you get money back, and it's against the income tax paid by the self-employed business owner. If they would have, and it applies if they would be entitled to receive the sick leave if they were an employee as opposed to being self-employed. So they will need to do the same kind of documentation of their inability to work. The amount of the credit is the number of days they're unable to work for a qualified reason, multiplied by the lesser of those dollar amounts, or those percentages, the same percentages of their average daily self-employment income for the taxable year, without regard to these payments, and subject still to the same 10-day and 50-day maximums. Again, expect some guidance here. If this applies to you, you're certainly not going to take your credit based on the screen. You're going to have to look at that guidance. Let's take an example. Employer paid $5,000 in qualified leave and is otherwise required to deposit $8,000 in payroll taxes, including taxes withheld from all its employees. So that would be income tax withholding and all of the other taxes that we talked about. They could use that 5,000 of the 8,000 that they owe and deposit the balance, the 3,000, when regularly required otherwise to deposit the 8,000. Let's assume, let's change the assumption and say if they paid $10,000 in sick leave and were required to deposit 8,000 taxes, then they could use the entire 8,000 credit, and they would have a 2,000 overpayment, which they could claim as an accelerated credit if they wanted to. I think in most cases you're unlikely to need a credit because the number of people getting this leave is, well, it depends, I suppose, but I think most employers are unlikely to run into the credit situation. Group health plan coverage requires while on EFMLEA, and that applies also to emergency family leave. So you need to continue the group coverage. Just like under EFMLEA, you would deduct the employee portion from what you pay them if you keep paying them something. If you're not paying them, then you would do it the same way you do with your EFMLEA, which is usually to either require them to pay or to allow them to go effectively into a loan situation and recoup the employee portion when they come back. Another thing to watch out for is if you're doing a RIF and you use measurement and stability periods for purposes of ACA coverage, this is sort of watch out for when COBRA kicks in, because sometimes if you're doing stability and measurement periods, you reduce someone's hours doesn't mean they lose coverage. Right away, if they're in a stability period, they only lose coverage at the end of the stability period or when they're no longer an employee. Another issue to talk to your brokers about, now this doesn't relate to the Act, but it relates to a lot of what's going on here, is some insurance companies are saying, even if somebody would otherwise lose coverage due to a reduction in hours, we're giving you some leeway for the next month or 2 months or on a temporary basis till we tell you otherwise to leave them on. So talk to your broker about that and see if you have it, and see what positions they're taking about that. So with that, we're done with the webinar here. Now, please enter your questions, and I'll get to as many of them as I can. So first question is, Karen says, if we already offer 40 hours of sick time and 80 hours of paid vacation, is the 80 hours on top of that? I think I answered that. 80 hours of paid sick time is not on top. It's actually underneath that. It comes first. Put that way. It comes first. If somebody wants to take the leave, they get that. Theoretically, they could elect to take paid time, paid sick vacation, or other sick time if they wanted to. But I see no reason why they would. You could take. They get this first and allow them then, if they need to supplement. If they're only getting paid 2/3, allow them to supplement with the other kinds of leave that they qualify for. But default is they go first, the leave goes first. They're not subject to the employer 6.2, but I'm not sure. The pay you pay to them is not subject to the employer's Medicare tax, but the employee still has to pay their Medicare tax. Yes, that's correct. I'm not sure about the rest of the FICA taxes, the beyond the Medicare. Honestly, I don't know the answer to that as I sit here. When earning the leave pay, is it subject to 401k contribution withholding? That's going to be determined by your plan document. Probably yes, but you need to check what your plan document says about that. Patricia's question, with this act, what happens if a staff has short-term disability through AFLAC or something like that? Can they take the short-term disability and this, or would they use this 12 weeks up and then use this short-term disability? I think if you have a short-term disability policy, it's entirely possible that could run concurrently with this kind of leave. It's determined entirely by that policy. Policy might say something like, if you're off work and not working, you get short-term disability, and you could be off work and not working, but it may have qualifying reasons that are independent of this. So I think it's evaluated independently. I don't think this act changes what happens under short-term disability at all. You either get it or you don't, and that's determined by the policy. What about employers under 50 not subject to EFMLEA? Are they now subject to the EFMLEA? The answer to that is yes, you are. That's the under 50 who are for the first time subject to you're not subject to EFMLEA, but you're subject to the EFMLEA, which brings along with it the obligations of not retaliating and notifying employees of their rights under the Act, and getting documentation of their leave request. So yes, it does apply. The emergency EFMLEA leave does apply to employers under 50. Can the amount paid at the 2/3 rate be less than the minimum wage per hour? It could theoretically be less than the minimum wage per hour, yes. The Act says you have to pay them, the rate you have to start with is either their pay or the minimum wage. And then you do 2/3 of that. So I believe that's right. Not 100% sure about that, but I believe that's right based on my memory. What if sick leave is taken and then later, non-consecutively, the employee needs to take emergency family leave? Does the first 10 days of EFMLEA not apply, paid apply? That would be interesting. So and the only way that would come up is if somebody took paid sick leave for a reason other than their children being home. So you ran out your 10 paid leave, came back to work. So you got a corona diagnosis and you were in quarantine for say 2 weeks. You got your sick leave paid, you get no more sick leave. Then you come back to work and now your kids are off school. Theoretically, well, if that applied, then you would not be entitled to any sick leave, and you wouldn't have exhausted the first 10 days of unpaid emergency family leave. So I think, yes, in that circumstance, unless the Department of Labor tells us otherwise, you would not be getting paid emergency family leave for those first 10 days when you come back. I think that's unlikely to happen, but it's possibly could, because I think in most cases, somebody who's, if they qualify for both at the same time, both the children being home from school and having some other qualifying reason for the sick leave, one of those other, they run concurrently. That's clear. You can run those two concurrently. You don't have to tack those on top of each other. You only get 80 hours of pay. And if it did qualify, then if it did qualify as time off because your kids were home from school, then you would have been running the first 10 days of family leave concurrently as well. So I think that circumstance is unlikely to occur, but as I explained, I think it could possibly happen. Next question, if we're choosing to pay our employees even though the work is not there, can we still take advantage of these tax credits? Absolutely, yes, you can. If they qualify, you want to, that's one of the things you want to be looking at. If you're one of those employers who's done that, that might be a reason you might consider going retroactive. You've already paid them, but now the government gave you this possible gift. And so you want to go back to your employees in that circumstance, give them the notice, say, hey, we're applying this as of back to whatever date you pick, back to the beginning of this week, and ask them for the support and see if you can get your credits running for you. Question about EFMLEA and EPSLA, that's a spelling mistake. It's just emergency EFMLEA. Next question, if you have seasonal interns who are scheduled to end work on April 15th, what is owed to such temporary employees? Well, I think that raises the question of, you have employees who you knew all along were going to stop working for you as of April 15th. Question is, were they going to terminate on that day, or were they going to remain employees who just weren't scheduled to work for a long time? So the answer is it depends. If they're no longer employees, then there's no obligation to pay them anything. That's clear. Whether you can terminate their employment at that point, I think comes back to what was the arrangement when you entered into it. And if you have some situation where you were going to keep them on as employees, but they weren't going to be scheduled to work, well, then it comes back to, if you're not scheduled to work, if you wouldn't be scheduled to work, there's no entitlement to pay, but they may be entitled to protection under EFMLEA because they're still an employee and you can't terminate them. The practical implication of that is probably nothing at the end of the day for most employees. Question, if an employee is furloughed due to business conditions and subsequently develop COVID, are they eligible for either sick pay? No, they're not, because they were furloughed and therefore not eligible to work. The amount they would have worked had they not developed COVID is 0. And therefore, there's no obligation to pay them anything because they haven't lost any work due to the fact that they got the COVID diagnosis. How do we document someone cannot work because they have to take care of their children? For instance, schools are closed, but that does not mean they cannot work as a result. So the way I'm approaching this is I'm going to have the form that's going to say, if you want to claim that leave, you're going to claim, I can't work because my children are off. Then some of the documentation you'll need to provide is, show me something from the school or the state closing the school. Something from the school saying we're closed due to the coronavirus situation. That's number one. The school has to be closed. Then explain to me why you need to take care of this person, why you can't work. Give me a narrative that says, I can't, why? Why can't you work? Just because they're home from school doesn't necessarily mean you can't work. I think you're going to have to take what the employee tells you and then judge it based on what they tell you and decide, make a judgment. Can I go with what they told me? Does it make sense? And pay them and not have them work? Or is what they're telling me nonsense and they could work? So a lot of times you will get something, you'll probably get something like, you want the explanation to address why they can't work, and it might say something like, I'm their sole caregiver. Well, then you're going to have to say, you're going to pretty much have to take what they say, but you might be able to go and follow up and ask some follow-up questions like, could you get somebody else to take care of them, or can your spouse take care of them? I think as a practical matter, you're going to basically take what the employees tell you and go with that. You're not going to push back very hard unless what they're telling you is pretty much on its face nonsense. What if an employee is sick from COVID and unable to work for more than 10 days? Even if there's no remaining paid leave, what is the policy on maintaining employee and health insurance? Okay, so under the Act, if they're sick from COVID-19 and unable to work, then you don't have to pay them any more sick leave because you've run out of the 10 sick days, assuming they otherwise would have been working full time. And there's no pay leave. What's your policy on maintaining their health insurance? Well, that comes back to, that's a big question, and the answer is it depends. It depends on what your regular policies are with respect to employees who can't show up for work. What would you expect from them if they weren't sick? Do you have other sick leave that you need to give them in addition? Do you need to give them regular FMLA leave? Are you subject to regular FMLA? If you're subject to FMLA, well, then they're sick and they're unable to work. They need to get unpaid leave, which they can substitute for vacation or other leave. So then you just start working through, okay, the Act doesn't apply, but it does preclude me from retaliating, and what other kinds of leave would they be eligible for? And the knock-on of that is, if somebody's on FMLA leave, well, then you can't terminate them from your health insurance coverage, and if they are in a stability period, as long as they're your employee, you can't terminate them. You cannot terminate them from your coverage. And then also, what does your health insurance policy or other documents, if it's a self-insured plan, what do they say? And they could say a lot of different things about how long somebody can be on leave, all the way from when somebody goes on leave, if they have zero leave other than FMLA, if they have 0 hours or less than X number of hours, then they're terminated from coverage, all the way from that to they can stay on for 6 months. And then the other consideration is COBRA. And if you're in Arizona has COBRA, state COBRA from one employee, or if you're subject to the federal law, it's 20 last year. Maybe you have people who get on COBRA, and then the question becomes, do we want to pay their portion, continue paying their portion, even if they're on COBRA? So nuanced question, and I'm sorry, I can't be more specific than that because the answer is it depends. Okay, if we're paying people because there is no work, not because employees have a qualified reason, how do we document that? I'm not sure what that question means. I'm sorry. If in other words, everybody's laid off, but you're paying them anyway, well, like I said, maybe I didn't say this quite clearly enough. If you're paying people who aren't working and you voluntarily decided to pay them who aren't working, then you cannot make them take this kind of leave, because that would be putting them in a disadvantaged situation. Because think through the scenario, could go like this. You might be paying everybody now for 2 weeks, even though they don't have to work. But if you start charging these people against their bank, their federal entitled sick bank, and then 2 weeks from now, pressure becomes so great, you say, we're stopping paying everybody. Now we're not paying everybody, or we're cutting how much we pay everybody from, even though they're not working. Those people would be penalized by having taken the leave. And I think you would probably be subject to retaliation there. So again, it comes back to, it comes back to documenting. You only get this leave if you're unable to work because of the leave, because of the qualifying reason. So if I may have said something a little bit contrary to that before. I'm not 100% certain at this point. So with that, I think we are. Oh, another question: is the number of employees determined by work site or overall company numbers? That's a great question. It's not determined by work site. It's determined by employer, and the employer is determined under EFMLEA. I believe it's under EFMLEA. It could be Fair Labor Standards Act. There is a specific Q&A on the Department of Labor website that addresses this. And no, it's under EFMLEA. It's determined the same way as under EFMLEA. And in a nutshell, everybody on the EIN is definitely in one employer, regardless of divisions and all the rest that are below the EIN that's paying everybody. And there are some circumstances where two EINs could be treated as one. It's not the same as the control groups for retirement plan purposes. It's not as stringent as that, but there are circumstances, and under EFMLEA, the Department of Labor lays out kind of principles, including, do they share HR and management resources? Do they have common business arrangements? How much common ownership is there? And unhelpfully, they don't say precisely how you determine it. So it's a case-by-case basis. So if you've already done this determination for EFMLEA, stick with that. If you haven't, well, then you may have an issue. But read, one of the Q&As in the Department of Labor website addresses that specifically, and it basically pulls the language out about joint employers and related employers from the EFMLEA regulations. So question, so if the office is closed due to COVID restrictions, okay, we've got a medical office, not allowed to open, and we pay our employees, is there a type of documentation we need to account for us paying them to get the credit? Okay, if your office is entirely closed, this is a great question. Medical office, the state has said your medical office is closed. I think, I believe that's the case. If you're an elective surgery medical office. I mean, I'm not talking about this particular person, I'm just talking about medical practices. If your office is ordered closed, in other words, you can't legally open your office, then nobody's not working because of the COVID, because of them having a COVID situation. They're not working because of the broad COVID situation, but they're not working because they had a diagnosis or they had something. They wouldn't be working even if they didn't have the qualifying reasons. So there's no entitlement to leave, and you cannot get a tax credit for paying them. Well, that specific circumstance, definitely Arizona's sick time law applies, and you have to pay them out if they request it, and request leave because the business is closed, shut down due to a health emergency. That's clearly qualifies under the Arizona state law. So I would take credit against the Arizona sick time, and I would tell the employees I'm doing that and give them the option to opt out if they had decided for some reason that they don't want to for that sick time. You need to communicate that to your employees. And again, there are some nuances here. If you've communicated to all of your employees, I'm going to pay you regardless. Coming back later and saying, oh, I've changed my mind, I'm not paying you regardless, I'm paying you sick time. Well, you can't do that. Don't do that. But prospectively, you can say, because of the circumstance that qualifies under the Arizona sick time law, I'm going to pay you that first. And after that, what I'm going to pay you is something else. What is the something else? Maybe we come up with, it's leave. It's just paid leave that we discretionarily give people when they run out of sick time for the next, whatever, 2 weeks. so that you're not retaliating against people for taking the paid sick time. So there's some nuance there. Question: if we were previous to this, we're allowing employees to go into negative paid time off balances and use the state mandated sick time. Can we instead use the 80 hours of paid leave instead of backdating to 320? Absolutely. Not only can you, but you should. So this circumstance, I think, you closed your office, say last week, Friday last week, Arizona governor says close your office. You closed your office, said to your employees, we're paying you sick time. And we're going to even allow you to go negative on your sick time. Okay, they're all probably getting negative now, or soon they will be, but certainly by April 1st. Let them go negative. Once you hit April 1st, you better stop charging their Arizona sick time, because you have to pay them the federal law. So to the extent that you're paying them, and you have to, under the federal law, to the extent they qualify, you better not be charging their Arizona sick time as well. You better pay them the federal, and not debit their other sick time or their vacation time, for that matter, if you're using a negative vacation bank to keep paying people. Okay, I think that is all I have. I will be posting the website, the webinar to the website later today, and I will also be posting an update on to all of you with information about the forms that I'm going to be offering over the weekend. Meantime, hold hands figuratively and stick together. Thanks.